Thank you, Chairman Johnson, Chairman Conyers, Ranking Member Coble, other distinguished members of the subcommittee. Thank you for holding today's hearing on H.R. 4115, the Open Access to Courts Act, which I introduced with Chairman Johnson and Chairman Conyers on November 19th. The Supreme Court's decision in Ashcroft versus Iqbal was the subject of a hearing I chaired in the subcommittee on the Constitution, Civil Rights, and Civil Liberties on October 26th, entitled Access to Justice Denied, Ashcroft versus Iqbal. It is the legislative response to that hearing's findings that bring us here today. What is really significant about the Iqbal decision is that it sets up a very stringent new standard that prevents people from having their day in court. It does so not based on the evidence or on the law, but on the judge's own subjective criteria. Rights without remedies are no rights at all. That's an ancient legal maxim. All Americans are entitled to have access to the court so that their claims can be heard, the evidence weighed, and their rights can be vindicated. Without recourse to the courts, our rights are merely words on paper. In Iqbal, the court established a new test that federal judges must use when ascertaining whether civil complaints will withstand the motion to dismiss under Rule 12b-6 of the Federal Rules of Civil Procedure. Rather than questioning, as required under Rule 8a-2, only that the plaintiff had included, quote, a short and plain statement of the claim showing that the pleader is entitled to relief, unquote, it dismissed the case not on the merits or on the law, but on the bald assertion that the claim was not plausible. In the past, the rule had been, as the Supreme Court stated in Conley v. Gibson, that the pleading rules exist to, quote, give the defendant fair notice of what the claim is and the grounds upon which it rests, unquote, not as a substantive bar to consideration of the case. Now the court has required, in effect, that the pleadings serve as a substantive bar to the consideration of the case by requiring that prior to discovery, courts must somehow assess the plausibility of the claim, dismissing claims the court finds not plausible, before discovery and without submission of any evidence. This rule will reward defendants who succeed in concealing evidence of wrongdoing, since claims will be dismissed before discovery can proceed, whether it is government officials who violate people's rights, polluters who poison the drinking water, or employers who engage in blatant discrimination. Often, evidence of wrongdoing is in the hands of the defendants, and the facts necessary to prove a valid claim can only be ascertained through discovery. The Iqbal decision overturned, and some of the statements of the last few minutes assumed that, or asserted, that my bill would establish a new requirement, a new standard. In fact, it will simply reassert the standard that existed for 50 years until the Iqbal decision. The Iqbal decision has overturned 50 years of precedent and will effectively slam shut the courthouse door on legitimate plaintiffs based on the judge's subjective take on the plausibility of a claim rather than on the actual evidence. At our hearing on Ashcroft versus Iqbal, we heard compelling testimony from the witnesses that the Iqbal decision has resulted in a substantial departure from previously well-settled practice in civil litigation. Several witnesses said the new standard put forward by the Supreme Court to decide a motion to dismiss a civil complaint amounts to a heightened pleading standard. Professor Arthur Miller of New York University School of Law, an expert on civil procedure, testified that, quote, what we have now is a far different model of civil procedure than the original design, close quote. We also heard from seasoned litigators. John Vail of the Center for Constitutional Litigation stated that there is, quote, no doubt that the Supreme Court intended a sea change in pleading law, close quote. Debo Agdebule of the NAACP Legal Defense Fund referred to the Iqbal decision as a, quote, judicially heightened pleading barrier erected by the Supreme Court, close quote. These three witnesses agreed that a legislative response like H.R. 4115, the Open Access to Courts Act, is very necessary. In addition to our witnesses, a diverse coalition of 36 civil rights, consumer, environmental, and other organizations support a legislative response to Ashcroft versus Iqbal. Mr. Chairman, I ask that a copy of their letter be included in the record following my testimony.
Without objection.
Thank you, Mr. Chairman. H.R. 4115 would restore the notice pleading standard that existed prior to Ashcroft versus Iqbal, a standard that was articulated over 50 years ago in Conley versus Gibson. Notice it would not establish a brand new standing opening the courthouse doors to all sorts of frivolous claims. It would reestablish the pleading standard that existed for 50 years prior to Ashcroft. Using the language in Conley, The Open Access to Courts Act provides that a complaint under Rule 12b6c or e cannot be denied, quote, unless it appears beyond doubt that the plaintiff can prove no set of facts in support of the claim that would entitle the plaintiff to relief, close quote. That is not language that I invented. That's language from the Conley decision of roughly 50 years ago. That was the correct and workable standard for a half-century. It is well understood and practical. The Open Access to Courts Act would simply restore that time-tested standard. Mr. Chairman, this Supreme Court seems to be engaged on a crusade to deny access to the courts increasingly to litigants of all sorts by tightening and redefining the standing standards, and that's a constitutional doctrine we can't correct, and by redefining and amending through court ruling, the rules of civil procedure, a change we can correct and should by passing this bill. Again, I thank you, Mr. Chairman, for holding today's hearing and for your leadership on this issue. I look forward to working with you and with the other members of the subcommittee and the full committee to restore the rights of all Americans to a day in court by enacting H.R. 4115, the Open Access to Courts Act. I thank you. I yield back the balance of my time.